second question with yourself, Nick. So we've got two questions, but they pretty much deal with one similar topic. This is surrounding basically the floods that have been happening and the various tornadoes. And then Bruno, because it's pretty much two questions in one, you feel free to just chip in here as well. The first one deals with was the one in Uitenhage, which is the Eastern Cape, floods and tenants. There's a clause of the leases, clause 20.2, that basically says, must the owner refund the tenant their rent for the rest of the refund the tenant their rent, for the rest of the month if they cannot occupy the property as it is uninhabitable. And then the second one basically blends into this one, but goes more into detail. It might be a little bit more complicated. This one says that the tenant terminates the lease early. The terms of the lease state that the tenant has to pay 2 months rent in advance for the 2 months after the new expiry date, right? In this instance, the lease expires 31st of May. Making the tenant then obviously liable for the rent for June and July, which is the 2 months, if no replacement tenant is found, of course. It's pretty much straightforward. Now, nature then took place during that one. And then on the 3rd of June, the estate and surroundings were hit by a tornado. And the apartment was, of course, Nick, badly damaged to a point whereby the entire property was once again unlivable. Hence, now obviously the agents or the landlord cannot market for a new place or cannot market for a place for a new tenant. This prejudices the outgoing tenant, and the landlord is still out of pocket. The question then, is the outgoing tenant still liable to pay the 2 months rent, even though they cannot place a new tenant in any case?
Okay. Right. Perfect. So what's really important when you're looking at questions about damages and things that happen to properties, okay, is you really need to look into the contracts that are entered into between the parties, okay? And this is why fundamentally we when we talk to landlords and we say what you need to do is you need to get good lease agreements in place that have clauses that deal with these circumstances, okay? These are the kind of clauses, people are more familiar now with force majeure because COVID was something that force majeure came up as a sort of, is this an act of God? And now with the floods, with tornadoes, these are what are termed force majeure. They're acts of God. And they are something that generally you would hope is a very rare occurrence, if an occurrence that ever exists whatsoever, okay? But it's one of those important things that you really should deal with in your lease agreement. And if you never invoke the clause, fantastic. You were very lucky in the circumstances. But when they do kick in, it's very important that you deal with things like this, okay? So I'm going to try break down a couple of the important things that we deal with when we look at our lease agreements. And if you do have a lease agreement with your tenant, please make sure you are using a proper lease agreement that's up to date. There are available lease agreements within the market that deal with these things and will protect landlord tenants in the circumstances. So the first thing is, with regards to the first question, the floods, they say obviously the property is uninhabitable as a result of a flood that happened recently. The first consideration you've got to do is you've got to look at your lease agreement and find out how rental is payable in respect of this particular lease. What I mean by that is, in normal circumstances, when a lease agreement is concluded, okay, naturally, what would happen is rental would generally be payable at the end of a particular month. So your tenant occupies for a month and they would pay their rent. Now, in contract law, okay, it's become common practice for this position to change. And you will see in 99% of lease agreements, it states there that rental is payable monthly in advance. Okay, that's not the natural position of a lease agreement in law. We have contracted so that the rental is payable monthly in advance. Okay, so you pay your rent on the 1st, and everyone's very familiar with this. That is a result of contract law and lease agreements saying that that's when the rental is now due. Okay, so that's the first consideration. If rental is payable monthly in advance, it's due on the 1st for the full month. That's when it's payable. And lease agreements will have clauses saying payable monthly in advance without deduction set off, whatever the case is. So that's when the rent is due for that full month. Okay. That does presuppose that there's going to be free use and enjoyment for the rest of the month. And if that free use and enjoyment is interrupted during that particular month, okay, there is a possibility for a tenant to say, well, I didn't get free use and enjoyment for whatever period during the month that is. Put aside for the moment, the natural disasters or whatever the case is. If, say, the landlord comes on the halfway through the month and says you are no longer allowed to use this property freely, then there is no doubt that the tenant can say, but I should be entitled a remission for that half a month that you didn't actually give me free use and enjoyment. Okay, so that is our standard rule. And if the property is put into a position where it is damaged and there isn't free use and enjoyment as a result of a flood, it stands to reason that the tenant could do the same thing and say, well, I didn't actually get free use and enjoyment of the property for whatever period. Okay. Now there's a second consideration you need to look at, and that is clauses dealing with acts of God. Okay, so there generally are clauses in lease agreements that deal with acts of God, and they will say something. Okay, remember these clauses can be constituted however, but that clause is going to say that, if there is an act of God, it's not going to affect the landlord's claim or something to that effect. You need to then consider the provisions of that particular clause in your interpretation of, well, what happens to the rental in the circumstances. And those clauses are, in fact, recognized within our law, absolutely enforceable in the circumstances. So our writer has said, well, they've mentioned one clause. Unfortunately, you're going to have to consider a number of different clauses in order to get your answer on this. So I can't give a specific answer to our writer. It is something that you have to consider the lease agreement holistically in order to find out exactly what it is. There's a possibility that there's a remission which might be due to the tenant, unless there's another clause which catches you at the end. So unfortunately, to our writer, I think you do need to send in your lease agreement, let someone actually have a look through the lease agreement holistically, and then to just touch on the second question. Okay, so the second question, it seems to me, relates to early cancellation of the lease agreement. Okay, and in this lease agreement, they've written in a clause that says, in the event that there's an early termination, there's going to be a 2-month penalty. Okay, now this when you see a clause like this, a lot of our listeners will think, oh, well, that relates to Section 14 of the Consumer Protection Act, which obviously says if you terminate an agreement early, you are liable for a reasonable cancellation penalty. Okay. The thing to know about Section 14 is it doesn't actually state what a reasonable cancellation penalty is at all. It says it must be reasonable, but then it goes no further to actually define what reasonability would be. And the reason that the legislature does this is because what is reasonable in a given circumstance is different depending on the circumstance that exists. So there are a million different types of what would be reasonable, depending on the type of agreement that's entered into, the facts surrounding it, how long is left on that agreement, etc., etc., etc. So there's no way for the legislature to codify what would be reasonable in the circumstances, and it's left up to interpretation based on the facts and perhaps, a court to say, well, this is what we would deem reasonable in the circumstances. Now, what a lot of people do is they write into their lease agreements what they would deem to be reasonable. So a 2-month penalty. Okay, and that's absolutely fine. You can do that. It's an acknowledgement by the parties. This might be the reasonable amount in the circumstances. That is a double-edged sort of sword. Okay, because it might be that is a reasonable amount, and that's absolutely fine. It gets paid, and there's no question about that. It might be that you lock yourself into a reasonable cancellation that might not be reasonable in circumstances. Either it's too little or too much. Okay, but the fact that you've signed that agreement with that amount in probably is going to mean that you're going to lock yourself into that particular amount. You need to be very careful about taking positions, in your lease agreement as to what's reasonable before you know that the termination actually exists. But with regards to this, so they're saying, well, there's a 2-month early cancellation penalty, okay? And now there's been a tornado that's come through and actually destroyed the premises so that the premises cannot be let out at this point. What we don't have here is how long, when the lease agreement. Oh no, they did say the lease expires on the 31st of May.
31st of May, yeah.
Okay, 31st of May, and then they charged a 2-month cancellation penalty in the circumstances. It seems to me that regardless of whether that property is going to be let out or not, that cancellation penalty was going to apply to this particular tenant. And I don't think that's going to be affected by the fact that a tenant hasn't been placed. Interestingly, though, I do think, and Bruno, I don't know if you share the sentiment, it would have been different if it was in the opposite direction. So if the lease agreement came to an end on the 31st of May, and they did place a tenant on the 1st of June, okay, there is a question as to whether that cancellation penalty is in fact reasonable in the circumstances. But the fact that the property we're dealing with the facts of this particular circumstance, the property has been damaged by a tornado. Okay, so a tenant can't be placed. That wouldn't have an effect on that cancellation penalty, and it could still be charged in terms of the lease agreement as agreed to by the parties.
Mm. Yeah, I agree. It's an interesting one, though. I was just thinking I just want to say it out loud. If the property can't be occupied, so now I suppose it's what happened first. If the tenant gave the notice that he didn't want to be in the premises anymore, and there was a subsequent act where the property got damaged, then he's made his bed and he's cancelled. So sorry, the penalty would apply. What's interesting is, so obviously, if the property gets damaged, it goes back to your first question. So number one, there's no actual need in my mind, depending on what the lease says, for the tenant to now try utilize a CPA to give notice, despite, for example, still having 6 months or a year left on the lease. As Nick mentioned, the property is no longer occupiable. So also just be careful what remedies a person relies on when trying to get out of leases, because I don't think that one would need to worry about the CPA Section 14 specifically reasonable cancellation penalties if in reality the landlord is unable to perform in terms of the contract. I think that's a different conversation that needs to be had with the tenant. But if the tenant has already given notice, a different conversation. Yeah. Well, Nick, I don't know actually what you think, but the reality is no tenant is going to be found for the property. That's not necessarily the tenant's fault at this stage in time. No. Would the penalty actually be reasonable if the property is completely destroyed? Because the tenant wouldn't have ever paid that rent to begin with, and they would have never found a tenant to begin with. So the reality is, should there even be a penalty? There's no costs, there's no loss of income. I suppose to a certain degree, it also depends on the extent of damage. But yeah, I don't know. It's an interesting one. I've never, the timing though would have to be perfect for that question to be answered.
Yeah, no, you're right. And one of those things for our viewers, this is one of those questions that, hypothetical situations that you're just praying for a legal case to go through a court to actually get a determination, but we continue to wait.
Yeah.
All right. So thank you to our viewers for watching for today's 2 questions and answers. That does bring us to the end of today's session, and we'll be joined by you guys again next week. And thank you very much to the experts today. Thank you.
Awesome.
Guys. Thanks, guys.
Cheers.